nei confronti dei relatori che hanno dato la disponibilità a partecipare a questo ultimo seminario del lungo ciclo che è iniziato ai primissimi di marzo e si è sviluppato in questo arco di tempo di 3 mesi. Gli argomenti sono stati tutti di grande interesse, focalizzando l'attenzione sulle diverse forme di traffico illecito che diffuse vicino al Mediterraneo, ma un respiro più ampio, sempre internazionale e in particolare europeo. Certamente però non vi nascondo che il tema del traffico illecito di beni culturali, lo dicevo poc'anzi al collega Greco, rappresenta per molti di noi, certamente per me e per alcuni colleghi con cui abbiamo preparato questa traccia di ricerca, un aspetto davvero stimolante per la sua ma anche, non lo nascondo, per il fatto che sì, grazie. Per il fatto che Sicilia e quindi abbiamo questa grande tradizione di patrimonio culturale che rappresenta per noi una costante visione di quello che questa terra è stata. Basta camminare nelle nostre città e vederla, questa enorme ricchezza. Dunque il fatto che dei penalisti, se non forse più in generale, visto che ci sono anche dei colleghi che provengono da altre discipline, dei giuristi si occupino di questo tema, è all'inizio forse un po' anomalo, ma addentrandosi appunto in questa materia ci si accorge quanto sia importante che questa ricchezza venga adeguatamente tutelata. Io non condurrò la discussione, sarà Alessandro Spena a coordinare questo seminario finale, ma ci tenevo a ringraziare il collega Stefano Manacorda, sempre disponibilissimo in tutte le attività che organizziamo, e poi essendo uno specialista di così tanti argomenti, il motivo è proprio questo che lo disturbiamo così di frequente, per cui appunto per lui è un po' chi è causa del suo mal pianga se stesso, si dice in italiano, quindi le nostre reiterate richieste sono in parte dovute alla sua ampiezza di interessi. A special thanks for their colleague from Greek that now it's in Denmark for a specific research. We are very interesting to know the different things of your research. E infine un ringraziamento anche alla dottoressa Federica Lachioma, che per ora vediamo soltanto nel telefonino, ma confidiamo che potremo vedere direttamente tramite Teams attraverso il collegamento un po' più avanti. La dottoressa Lachioma è qui alla Procura della Repubblica, Sostituto Procuratore della Repubblica, e in particolare ha sin dall'inizio partecipato ai moduli del corso Jean Monnet con grande attenzione, partecipazione diretta, e di recente ha anche contribuito con un importante scritto ai lavori che sono stati pubblicati all'esito di una ricerca precedente dai contenuti simili, ma che appunto non presentava lo specifico topos della tutela del patrimonio culturale. Quindi la ringrazio, questo è anche suo essere recidiva nelle nostre iniziative. Non dico altro, darei direttamente la parola a Alessandro Spena e seguirò con attenzione, come ho detto, i lavori.
Grazie Vincenzo, anch'io saluto tutti. Soltanto comincio in italiano soltanto per appunto dire a tutti coloro che ascoltano questa questo seminario di oggi, che oggi, anche in ragione del taglio internazionalistico che ha il contenuto della nostra discussione, il seminario essenzialmente si terrà in lingua inglese. Good afternoon, everyone. Good afternoon to our guest speakers, and this is, as Professor Militello already said, that this is our last JM Jean Monnet seminar for this year, scheduled for this year. As many of you probably remember, in the last seminar, we basically focused on illegal trafficking in cultural property from a domestic perspective, from the perspective of domestic criminal law. We analyzed Italian criminal law concerning illegal trafficking in cultural heritage. We also said something about the agencies who are in charge of law enforcement in this subject matter. Today, we will expand our scope, our focus, to a international, supranational, or if you prefer, to a global perspective, and on the other hand, also taking into account both legal and extra-legal expertise on the matter. Our guest speakers, all of whom are very welcome, are Christos Tsirogiannis from the Aarhus Institute of Advanced Studies in Denmark, who is a forensic archaeologist, and Stefano Manacorda, who is a professor of criminal law at the University Luigi Vanvitelli in Naples, and Federica Lachioma, who is public prosecutor at the courts of Palermo. Well, without much further ado, I just give the floor to our guest speakers. I only ask to our speakers to limit themselves to, I would say, to 40 minutes, 40 minutes per speech. And so I give the floor to Professor Tsirogiannis. Please.
Thank you so much. Thank you for inviting me. I'm gonna share now my PowerPoint. I hope you have the first screen in front of you. Please verify that you can see.
Yes.
Okay. Yes. I wanted first of all to say that I owe to many people the fact that I'm researching what I'm researching, and many of them are Italians. So it's a special privilege for me that I'm being invited by Italian colleagues, so to speak, because we are all colleagues fighting the same problem in this case. Therefore, I chose to first show a background of this research and for what I will talk about today, selecting, as you see at the title, certain cases that highlight these certain problems, but that connects all of us, showing the people who participated both in the trafficking of these objects in these selected cases, but also the people, especially that I had the privilege and the honor to cooperate with in order to bring them into an end, some of them. So I would like to first start with this brief introduction and to say that because of the Italian authorities, it was made possible to have a series of raids and the confiscation of series of archives starting in 1995 and until the most significant ones in 2008, but there are others before and mainly after, as well as during. Everything started from what you see at the top, and I will show you now with the laser pointer here, which is the well known by now to most of you organigram that is actually depicting the Italian branch of the International Illicit Antiquities Network, naming people in various levels, and most importantly, Giacomo Medici and Gianfranco Becchina, the two rivals, that they, in a way, they have ruled the whole Italy in terms of receiving illicit objects coming from illicit excavations taken part in Italy. Medici from north of Rome mainly, and Becchina, Sicily and South Italy especially. You can see also part of the photograph archives that they have been confiscated during these raids, while objects also were found in the warehouses that they kept in Switzerland. But also there was the duet of Robin Symes and Christos Michailidis that you see here, an operation that took place in Greece, and I was particularly privileged to be part of the raiding party with the Greek Police Art Squad and the Greek judicial authorities, where we found more or less similar things, so antiquities as well confiscated, but mainly the photographic archive of the top illicit antiquities dealers in the world back then, so to speak from 80s roughly to early 2000s, and who have been receiving objects both from Medici and Becchina. So in a way, the three of them form a kind of the different levels within the same network, with Symes and Michailidis on the top, taking the place of Robert Hecht, that it is depicted, he is depicted, referred on the top of the confiscated organica. So I have just examples of the most significant raids and the most significant archives here. The Giacomo Medici raid in Geneva in 1995, Gianfranco Becchina in Basel, Robert Hecht in his Paris apartment, Marion True, the former chief curator of antiquities at the Getty Museum, who had a summer house in Paros. I have also participated in that raid with the Greek Police Art Squad. 15 days later, at the Schinoussa Island nearby Paros, in the same bunch of islands where Symes and Michailidis used to have their villa, where we found their archive. Frida Tsakos, again in Greece, in the region of Theotida. Horiuchi, Noriyoshi Horiuchi, a Japanese dealer, antiquities dealer, has been raided in Geneva, and the significant archives that have been generated from these raids. It has been possible, so to speak, to come closer now to the speciality of most of the people who are participating in these sessions here and are listening and looking at us. It has been possible for the Greek side, at least for us, for me, to participate in all this because of the successful efforts of the Italians that took place first. And that is owed especially from the judicial side of view to prosecutor Dottore Paolo Giorgio Ferri, and also at the same time the head of the Carabinieri Art Squad, Roberto Conforti, the general, the late now Roberto Conforti. At the same time, at around 2004, 2005, equally in Greece, Mr. Ioannis Diotis was the head prosecutor who took over the case from the very beginning, actually, the case of the Schinoussa raid and the Marion True raid and the relevant starting of claims and repatriations for Greece, and the then head of the Greek Police Art Squad, equally the now late Georgios Gligoris, who was killed in action in a traffic accident in 2009. It was in late 2005 that the initial meeting between Paolo Giorgio Ferri and Ioannis Diotis took place, and literally but metaphorically speaking, since then they were under the same umbrella. So it signified this photograph a cooperation that lasted at least 2 years between the two countries because of these people mainly, and brought together other people like me with Italian forensic archaeologists, especially the pioneers of forensic archaeology, who are Italians, and they are Dottoressa Daniela Riccio and Mr. Maurizio Pellegrini. These were the people who has been working as forensic archaeologists representing the Italian state and researching all this confiscated material that the Italians first made possible and raided and confiscated, the photograph archives, identifying objects all around the world in American museums starting from, and in other areas like dealers' galleries, auction houses, and private collections, in order to make possible hundreds of claims for the Italian state. Only in 2006, when the Greek state managed to do the two raids, the Marion True raid, and especially the Simons Michailidis raid in Schinoussa, and found the relevant archive, it was made possible to initiate this cooperation and exchange information that led to repatriations also for Greece. For example, this case, it's the golden wreath from the Getty Museum. And here is the invoice with which the Getty Museum bought it from the dealer Christophe Leon, an object that was a unique object that was initially looted from Greece in the early 90s, late 80s to early 90s, and was sold as being also referred to into the invoice, as you can see, Private Collection Switzerland, which is exactly here, named in 1993 for $1.1 million back then. However, because of our cooperation and the exchange of the digital archives between the two countries, so we received as Greeks copies of the Medici in Pekin archive, and we gave a digital copy to you, to the Italians, of the Simons Michailidis archive. And we were able, from the Pekin archive, to discover this photograph depicting the same wreath, golden wreath, Macedonian wreath, but also the envelope in which it was included with a fake address, but from Thessaloniki, and most importantly, original postal stamps with the date, which became eventually the proof of the origin of the looted object. And here is this photograph with the then Prime Minister in 2006 and the then Minister of Culture celebrating the return of the golden Macedonian wreath to Greece at the National Archaeological Museum in Athens. So this is the team that made it possible about 15 years ago, and it was the first case that was repatriated due to the archives. So the former Minister of Culture, Yorgos Grigoris, the head of the Art Squad, Nikolaos Zirganos, a journalist who greatly contributed with evidence and help to many repatriations. I was about 15 kilos and 15 years and 15 kilos younger and lighter, respectively. But especially for me, led to a great friendship, not only cooperation with Dottoressa Daniela Riccio and Mr. Maurizio Pellegrini here. We are at the Villa Giulia, at the gardens of the Villa Giulia in Rome, much after the official cooperation between the two countries on a judicial and police level stopped. We continue to cooperate, we continue to exchange information, identification, and so on, which is so fruitful for our countries, just because We like it. This is what we do in our free time. It's our passion and so on to continue this kind of research, even if there is no support anymore officially from our countries. I would like to show just examples of the repatriations that took place mainly, but not exclusively, because of the work on these confiscated archives. The Efronios crater that you all know, of course, and the Morgadina statue. I chose deliberately Italian and Greek objects to talk about in this case, although our research is not exclusively on Mediterranean objects in particular, but in respect to today's talk. The golden wreath, the trapezophoros of the two griffins attacking a female doe, young doe, identified by Pellegrini and Riccio at the Getty Museum and returned to Italy. The Kore statue, archaic from Greece, returned together with the wreath and two more objects from the Getty Museum. And just as an example of from auction houses that I found two Canosan craters from Italy, South Italy, at Christie's in 2012 in New York, and they have been repatriated to Italy. The whole story, probably known very well to you, is the Medici conspiracy book. The 2006 original edition, the 2007 paperback edition, however, this is the most complete one, written by Peter Watson and the Italian excellent journalist Cecilia Todezzini, narrating, including this version, the extra chapter on Greece by Nicolas Zirganos, the journalist, who contributed also to repatriations, and mainly also focusing on the work of Maurizio Pellegrini and Daniela Riccio, here depicted incognito, however, with a camera in their lap, at the gardens of the Getty Museum in California, in Malibu. The years later, I have been privileged even to work with my brother, who is a computer scientist. And together we published an edited volume in Oxford called The Connected Past at the University of Oxford. We took the book from the Medici conspiracy book that I showed you just before, and we analyzed only the 92 cases that are being referred there. Nothing else. None of the extra cases that me or Pellegrini or Riccio have produced since then. And we have produced hundreds and hundreds of them that we haven't got any time yet to publish. But just on the 92 cases referred to the book, we came about with this map that shows the nodes and how the people and the institutions and the universities and the auction houses and the dealers are interconnected. We show that some nodes are obviously more important because they are more repeated. We examine the fact that what if these nodes disappear? Does the network, the trafficking network on an international level still working? Can it be still working? And we found that yes, it can work. But most importantly, my brother especially created an algorithm which predicts possible other connections between three people, or even if we know the connection of the two of them, and we do not know the third. So a valuable tool to police forces and judicial authorities that they want to take a step forward on researching this area as a crime. Furthermore, we created a more general map on the way objects are being circulated, which is much more elaborate than we knew internationally from 1970, which is the year of the UNESCO Convention for the protection of cultural property in general, and especially in antiquities, until 1995, which was the first raid, the Medici raid, the raid on Medici, Giacomo Medici. So this is what we knew from 1970 to 1995, and this is what we No, much more elaborated, only from the, I'm saying again, the examination of the 92 cases in the Medici conspiracy book. So that shows what kind of potential are out there for work, original work to be made with data that they are already published and available to everyone. I would like now to slowly enter to the certain cases and highlight problems, various problems, starting from judicial authorities issues and police authorities issues, but also other ethical problems that they are coming up as well. I will first show a couple of cases that highlight a very good cooperation as a way to understand the various degrees of less good cooperation or no cooperation at all that followed. So here is an example at the Metropolitan Museum of Art, where in February 2013, I saw this image at their website of the museum, and there it's just a photograph that they took randomly in order to advertise the newly bequested collection of fragments that once belonged to Dietrich von Bothmer, who was the chief curator of antiquities at the Metropolitan Museum, but at the same time he was acquiring antiquities for his personal collection, especially vase fragments, kept inside the museum. An obvious case that it shouldn't be accepted by the museum, yet it has been accepted, probably because they more or less knew that probably after his death, the collection will end up officially being owned by the museum, as it did. So when Dietrich von Bothmer died and all the procedure was finalized, about thousands and thousands of objects, you can see here 10,000 terracotta vase fragments have bequested. And this was a random example that they took a photograph to advertise the starting of the research on these fragments. So I saw this photograph, and then I took out the surrounding text, and I turned the photograph, and this is what I got into, but it was missing the main central fragment. And as you can see, is a Silenus and a Menad. And here is the beginning, the bottom, let's say, the foot of a large vase. But we are missing the central part. So we don't know if that object was illicit or not. Yet the shape of the missing part, the fact that it is central, and more or less I knew what to look for, led me very quickly to something, because I remember that I have seen something similar. And soon enough, I found this. And both should have clicked as a shape and as an image in that. And because I always liked puzzles since a child, I put the two photographs together, and I ended up with this. And it clicked. And therefore, that proved that it's the same object, is the missing piece. And the most important thing is that the central piece was delivered in 1913, so 100 years earlier exactly, by a contessa, an Italian contessa, from her gardens villa, found during garden works that were taking place there, and delivered to the Villa Giulia Museum, together with other fragments and a few of vases. And they have been, these fragments and vases have been subsequently, in the early 1920s, have been published in the series of Villa Giulia publications. And hence, I remember that I have seen it sometime, somewhere, and by searching for it, I found it. I notified my good friends in Villa Giulia, Maurizio Pellegrini, Daniela Riccio, and for what we had, and through Villa Giulia and the Italian Ministry of Culture, they managed to communicate with the Metropolitan Museum of Art. But I did that independently as well, asking for more information on the provenance. And the Metropolitan Museum never replied to me. And it was fortunate, because of Maurizio Pellegrini and Daniela Riccio, that this communication between the Italian state and the Metropolitan Museum was elaborated and led to the repatriation of the cap eventually to Italy. However, this is an example, although that has had a happy ending. It shows that it shouldn't be on personal connections that this should happen, but both the museum especially should have replied early. As I said, the cooperation continues, and with exchange of information, with exchange of identifications, especially for Italy, for the benefit of the Italian state, but also for the Greek state and other states that have suffered from the illicit trade and the theft of cultural material. Now I'll move to a second case. This is the moment that Philippe de Montebello, the then director of the Metropolitan Museum, is signing in Rome, in Italy, at the Italian Ministry of Culture, the agreement for the return of 21 objects, including the Euphronios crater. Several of them have been identified by Daniela Riccio and Maurizio Pellegrini, although they have not been credited by the authorities for their work, especially in publications and in exhibitions. The Association of Art Museum Directors in the United States in 2008 issued new guidelines how to deal with antiquities and provenance antiquities, and especially when someone has an information on them. And they updated these guidelines in 2013. And I've highlighted in this text, in particular, they state that in the event that a third party, i.e. an individual or someone else, brings to the attention of a member museum information supporting the party's claim to a work, like an antiquity, for example, the museum should respond, and I particularly would like to highlight this, will respond to the museum promptly and responsibly and take whatever steps are necessary to address this claim, including, if guaranteed, returning the work, i.e. the antiquity, as has been done in the past. Let's see, this is in theory. In practice, what happened? From the Giacomo Medici confiscated archive, I have identified through Polaroid images and regular print images this crater. It's South Italian, is still with soil incrustations on top before it has been cleaned, after it has been looted, obviously from a grave, because it is depicted intact, not in fragments, not broken and reassembled. But the same object, I discovered it on exhibition at the Metropolitan Museum of Art in 2007. I thought that it must have been included in some kind of deals with the Italian authorities. However, by 2014, when I saw that it was still there, it was obvious that it wasn't included in any deal for repatriation. So in 2014, I published my identification and the whole case, all the information that I had, and subsequently the photos also, at the Journal of Art Crime, the academic journal, saying that after Medici had it, it went and was sold in Sotheby's in June 1989 in New York, in a perfect condition. As you see, it has been cleaned. And then since then, it was acquired by the Metropolitan Museum and exhibited there. Now, after my publication, I immediately notified Mr. Maurizio Fiorilli, who was the head lawyer representing the Italian state in claims and negotiations with institutions and private collectors for the return of illicit archaeological material to Italy. He told me that he had just been retired And he, nevertheless, however, will contact the Carabinieri in order to carry out further investigations. For 2 more years, I haven't heard anything from anyone, either from judicial authorities or the Carabinieri or Sotheby's or the American authorities, although the publication was out there since 2014. And then I, after a meeting in UNESCO in 2016 in April, I've sent to 2 Carabinieri, one in Interpol in Lyon and one in UNESCO in the United Nations, the case with my article and the images, telling them that this is of importance for the Italian state. I have to say, from the 2, only Mr. Romano, a very kind Carabiniero at the United Nations, immediately and kindly replied to me in April 2016, saying that he forwarded to the Carabinieri in Rome all my evidence on the case. Still, for a year more, until May 2017, I haven't heard anything from anyone. And therefore, I directly notified the district attorney's office in New York, responsible for the vicinity of the center of New York, and therefore including the Metropolitan Museum of Art. And in June 2017, a month and a half later, the object, the crater, was confiscated from inside the Metropolitan Museum. The case has been, the true case, has been made headlines, front page at the New York Times on the 31st of July in 2017. As you can see, it is available on the internet. You can Google and find it, the relevant article of the seizure, and all the information are there. However, the repatriation of the object, I found it out only from the press, and it is really bad, but also indicative, the fact of the absence of the Italian authorities of any cooperation in this case. Leaving alone, of course, the obvious lack of cooperation at all to the Metropolitan Museum of Art, that never replied to any of my emails, either for the cap that you saw before and for the crater. I will move to a second case. Beginner's antiquities in Christie's in London were being sold. Here is an example on December 2011, so many years after the raid against Gianfranco Becchina, many years after the discovery of his archive and the initial repatriations for various museums, Getty, Boston, Cleveland Museum of Art, to name some, always with the work by Riccio and Pellegrini. Here is just an example that I identified a vase as being depicted in the Becchina archive, still with incrustations, probably coming originally from a tomb, and the same vase absolutely cleaned, removed the incrustations as it was shown for sale in Christie's on December 2011. Among with other pieces that I identified, I notified the great friend of mine now, Dr. Paolo Giorgio Ferri, retired prosecutor, and he told me that he will notify the Carabinieri. I've heard nothing since then, and eventually, a few years later, I saw in a press release that the same vase was included among other objects that the Italian state have repatriated. At least that showed me that the work had some actual results, despite the complete lack of cooperation between the people who, in theory at least, and in reality, I believe, we fight the same problem from the same side. Another example, and to show you that these kind of objects from the Becchina archive are being identified and returned to the countries of origin, i.e. to Italy in these cases, I'll show you one that returned to Greece. So in June 2017, from various Polaroids from the Bekin archive again, and this is just an example, showing the upper part of a funerary marble stele coming from outside of Athens. It has been looted from there. And the same one being on sale by Sotheby's in London in June 2017. Have identified and notified again the Interpol, the Greek art squad, the police art squad, and the object was eventually repatriated to Greece, as I found out from the press again, because there was an equal lack of cooperation with the Greek authorities as well. So these are the two examples that shows that despite all these popping up problems, the main thing is that the objects are coming back to the country of origin. So I will move now in relation to what I've shown you with these two last cases very quickly to the main case and the last case I would like to present. And this is a cup depicted Achilles, 5th century BC, Greek, but obviously coming from Italy, is depicted in Polaroid photograph, among other cups that I cropped for obvious reasons since we still are looking for them, and is depicted in the Bekin archive. And the same cup, I've identified it in Christie's in London in 2015, in October, on sale. So I notified again the Italian authorities, the Interpol. I've published the case in various websites, and I gave them for publication in newspapers and so on. The object was withdrawn together with 3 more objects that I identified, 2 of which were again from the Bekin archive. But since then, I've heard again nothing from anyone, which is again demonstrates the lack of cooperation that there should be, especially when someone is offering his work for free, doing it in the free time as a passion and not being the paid work. However, the same object, I saw it appearing again in 2018 in December at the Gorny and Moss auction house at Munich on sale. And not only it showed to me that in between there was no knowledge, at least from my behalf, on what may have happened, and a withdrawn antiquity reappeared on sale at a different country. But the most important was that the Gorny and Moss auction house advertised the sale of the object by saying the Italian authorities, after it was withdrawn from Christie's, have not requested return. And this is in the printed catalog of the auction house and in the website of the auction house, and it was sold eventually. So my question is, why we have objects from the Bekin archive, Italian objects, and Greek objects that are being repatriated, but some of them, they are not even claimed. They haven't even requested the return. And on that question, I would be very much happy to continue, always for free, to cooperate with Italian authorities. I'm always still available, either judicial authorities or police authorities, and find answers and push further, because other objects will come to the market in the same way. And we do not obviously want to lose the objects and their history by not even claiming them. And I personally find it very bad to be the seller of this kind of antiquities who is saying bluntly, quite clearly, that the Italian authorities have not requested return in their auction sale catalog, and to a degree insulting. Last thing before I finish my presentation, in order to be in the 40 minutes time, is that between 2015 and 2018, a new antiquities law has passed in Germany. And that antiquities law has been advertised, especially by Germans, as a much, much stricter than the previous one. However, when I notified the German authorities for this case and other cases in the same auction house at Gorny and Moss that I identified several other cases together with these and other objects. The German judicial authorities decided to return the withdrawn objects back to Gorny and Moss and to be sold. All of them were South Italian. All of them were coming from Italy. All of them have been eventually sold. That is quite telling both for the level of cooperation from the judicial authority side and also for how strict in reality is still the ongoing antiquities law in Germany that was advertised as stricter, especially if it has this kind of results, worse than the ones that we had with the previous law in Germany. With this, I would like to close my presentation, to conclude my presentation by saying that there are many more problems to be solved, as only these three cases have highlighted, other than the basic cooperation that in many cases is still lacking between authorities, between researchers, and between people also that they want to offer for free their work that they're doing out of pure passion. And yet, despite that it is, I think, important when it comes to national importance of objects that are being claimed internationally in order to be repatriated, objects that you especially understand because of your specialty that they are stolen property and stolen cultural property, which is something more significant. All these problems are needed to be solved. And I don't think that it is something difficult. I only think that it is some barriers that are being put quite recently, after 2008, that this particular cooperation that I showed you at the beginning with these particular people, Prosecutor Ferri, Maurizio Pellegrini, Daniela Riccio, General Conforti, have shown how amazingly can work and what kind of amazing results. Thank you very much for your attention.
Thank you, Christos, for remaining within the 45 minutes, but most of all for this fascinating overview on forensic archaeology as seen from your perspective. Yes. And at least now I know more or less what a forensic archaeologist is, something like an Indiana Jones going here and there in order to catch looted antiquities so that they can be returned to their state, to their legitimate owners, and so on.
Allow me to say, Professor Spener, thank you very much. Allow me to say two things. The first one is that forensic is a word that is usually used for anyone who is working on finding, discovering, and analyzing evidence on crimes, on any kind of crimes. In the case of archaeologists, forensic archaeologist is the one, therefore, who is analyzing evidence on crimes related to antiquities that have been looted, smuggled, or stolen from any country. In that sense, I am continuing the work of the pioneers, who are the pioneers Maurizio Pellegrini and Daniela Riccio. And I'm very honored to continue what they set the first norms in that field of forensic archaeology, to answer your question and stuff. As for the Indiana Jones, which is the last thing that I want to say, is exactly the opposite and exactly the one we are fighting against. So Indiana Jones is by Hollywood presented as an archaeologist, but in reality is a trafficker, is a looter who is exporting illegally objects, archaeological objects that he discovers, in order to be stored and exhibited in American museums, exactly as it happens in reality here. Therefore, is a looter, is not an archaeologist, but for obvious reasons, for Hollywood reasons, to apply in an adventurous spirit. Indiana Jones is something that, unfortunately, even the press have related as frequently. So we try to avoid as much as possible to be called Indiana Jones, but I see the reason that we do sometimes, although we definitely don't want.
Okay, Professor Militello will not be happy with that, since he is a big fan of Indiana Jones.
No. Me too. I am a big fan too. Yes.
This afternoon, one of my best heroes. I think there is a very problem for me.
I am sorry, Professor. I just have to say the truth.
Okay.
So since Professor Tsirogiannis has to quit our seminar at 6 o'clock, I would like to see if there are any questions now, instead of raising questions after the 3 lectures, as we usually do. So I would like to ask to the participants if they have some questions specifically related to what we have heard so far for Professor Tsirogiannis, or on the contrary, we could try to take some questions after the other 2 lectures, hoping that they will finish before 6 o'clock. Are there any questions now? It seems to me there are not any questions, but I would like to say just one thing, and it's this one, that I have learned very much from your presentation. Probably one thing that I think I have more clearly learned about that is that your work is very much concerned with luck, with randomness, with being lucky enough to individuate looted things around the world, and I think that I have understood that the role of luck in your work is very much increased by there being an insufficient cooperation between agencies or relevant agencies around the world. And would you please tell me if I have correctly understood this part of your presentation? Is it not?
It is a very interesting and important comment and point that you are making. Thank you for doing that. I would quickly say that it shouldn't be like that in both respects. In the second, starting from the end, it shouldn't definitely be the lack of cooperation like that. One privilege of being an academic is that I am obliged to publish in a neutral way exactly an account of what I have encountered, both as evidence and as behavior, cooperation, and so on, different degrees of cooperation and so on, in my publications, academic publications. So I always name people, and I always say step by step what have happened in order to be out there an account. I would very much happy to see equally authorities, especially police authorities from various countries, to do the same. I can see that I know that they have some constraints of doing so, but they are valuable data that they are not being given at all, both to the public and to us, to the researchers. And that is a major burden for our research. That is truly a kind of luck, whether you will get it or not, depending on how a police officer is doing well or not its work. The second thing about the identifications and how we proceed, it's definitely not a matter of luck. We are trying to systemize it as much as possible, both working on the archives and digitizing them, but also working and digitizing other kind of material. As you see here, I have my own personal collection of auction houses and billiard galleries catalogs, but I travel with them wherever I go. So, for example, I brought that from Cambridge, where is my permanent residence in England, here to Aarhus, to Denmark, to conduct the certain project that I'm doing here for the next 3 years. And therefore, we are trying to minimize the level of luck in our research. The fact that between me, Maurizio Pellegrini, and Daniela Riccio, we have more than 1,500 identification of antiquities all around the world so far, shows that the amount of the results that we have is definitely not a result of luck, but I can assure you it's a result of passionate, hard work that goes most of the times unacknowledged.
Okay, thank you very much.
Thank you.
So now we have an established tradition that we do a 5-minute pause between one lecture and the other. So just see you in 5 minutes. Okay?
That is fine.
Okay, see you now a while.
Okay, here we go again.
Eccoci.
Are we ready? Great, okay. Now I'm very pleased to give the floor to Professor Stefano Manacorda. Please, Stefano.
Grazie molte ai colleghi che mi hanno invitato. Anzitutto confermatemi che si veda e che il video e l'audio funzioni.
Tutto a posto.
Grazie mille a Vincenzo Militello per questa occasione rinnovata di incontro su tematiche rispetto alle quali mostro una semplice curiosità, a dire il vero, che cercherò di condividere con voi oggi. Ad Alessandro Spena, anche per la nuova occasione di incontro, a voi tutti, ai colleghi che hanno già preso la parola, a quelli che la prenderanno e agli studenti che oggi ci seguono numerosi. Well, I've been asked to take the floor in English today, and I hope it won't be too hard for you to follow me in English. And I will actually use a certain number of slides, and I think it would be also an help for everybody in order to analyze some legal issues I would like to deal with today. Let me say, first of all, that, I have a different approach compared to the one we just heard. As previously stated by Alessandro Spena, I'm a criminal lawyer. I'm very much interested in the international issues related to the trafficking in cultural property. And as I will mention during this very short presentation, I've been dealing with this topic in several occasions, both at the theoretical level and at the practical one. The issue I've been asked to give a speech today about is the one related to the international legal framework in terms of criminal law. I'm aware that in the previous seminar you had, I think 1 week ago or 2 weeks ago, you already had the opportunity to learn more about the Italian legal framework. My aim will be in a certain way complementary to the one which has been already developed. The idea is to present to you today, starting from a certain number of criminological elements, the international legal framework in relation to criminal law responses in this area. And let me say before I start my presentation and give you some details that for many years we suffered a certain lack of criminal law responses, and at least until very recent initiatives I will comment later. What we experienced in this area was a certain lack of criminal law. And this is quite amazing because, as my colleagues already know, and you, the students as well, of course, we, in many areas, we actually criticize the legislative efforts because they actually are sometimes characterized by a symbolic approach, by an overwhelming number of pieces of legislation. And this is something that doesn't really happen in the area of criminal protection of cultural property. Well, for a certain number of reasons that we probably will analyze today, we experienced, as I said, for many years, a certain, yes, I said the lack, or somebody said, a sort of underestimation by the criminal law of these phenomena. Well, I will try to pass to my slides and I will use them. What is clear is that you can see my face, I think, in the corner of your screen, but you can see here what is the topic I'm going to deal with today. So within the context of the international, European and Italian perspective and the judicial cooperation, I will especially focus on what I call the dimension of international criminal law in general, a broader sense. even if the previous amazing presentation that I really found very interesting from my point of view was already presenting some cases, I will state, in terms of introduction, I will present to you some cases which have been widely commented in recent years. The most important one has been already mentioned before, and is what is called Fano Bronze, or the victorious youth. This is the name of a very relevant criminal case, maybe the most relevant criminal case in Italy for the reasons I will mention here, relating to a bronze which has been found in the Adriatic Sea in 1964. So let's say more than 50 years ago. And the story came to an end, but not the last end, at the end of 2018, beginning of 2019. This is to say how difficult it is to tackle this phenomena. I don't want to give you details here. This is not the specific focus of what I'm dealing with today. The only point I want to stress is that, as many of you may be aware of, this statue, which, as I said, was found in the Adriatic Sea by some fishermen in the 60s, in the last century, has been sold to in the international market. And after a certain number of tradings, it came in the hands of the very famous Paul Getty Museum in California. And for many, many years, Italian authorities tried to tackle this case and to find the perpetrators, and some criminal proceedings took place in Italy. But unfortunately, the first ones brought to a negative results. There were no people who could be held responsible for them. Until, as I said, in 2017, a criminal court in Rome dismisses the case due to time limitation, and also denied the seizure of the statue. A few years later, another judicial authority started again to investigate into the case, and then the saga continued. I'm not giving you details, even if you can find them here, until the very last decision that I mentioned at the bottom of this slide, which is the Supreme Court, Corte di Cassazione decision taken at the end of the 2018, and which has been published in 2019. This is a very relevant piece of case law, where a certain number of issues that have been discussed, that I will try to discuss with you, have been ultimately dealt with by the Italian judges. I want to let you know which is the final outcome, at least for the moment. The final outcome is that the Italian Supreme Court confirmed that the seizure of the statute has to take place no matter where the statute is. We know that the statute is in the United States, is currently presented in the Paul Getty Museum, and even if this decision took place, the Paul Getty Museum didn't return the statue to Italy. There are many other cases I would be able to talk about. Every single case has its own specificities. In the previous slide, I was showing what is a very recent theft that took place in Amsterdam of a Van Gogh painting. So I'm not dealing just with antiquities, but also with pieces of art. And this is just one of the examples I could actually give to you of the looted art by Nazis that have been recovered even in recent times. And this is currently one of the cases where Italian authorities were involved in, well, I think you can recognize here a very famous painting from Klimt. Every single case I mention here is a sort of forward to what I will say to you in a few minutes. So I don't want to comment them. I just want to let you know that this is a very specific selection of hundreds of cases that could be presented. Some of them are famous, some of them are totally unknown, some of them have been brought to justice, some of them unfortunately didn't have any consequences, as my colleague said before. If I want to mention this case, it's because it took place a few kilometers from my home. So it's a Girolamo library, and this is also a judicial case. You may be aware that here in Naples, where I live, in 2018, 1,500 books were missing from one of the oldest library in Italy. And the director of this library was arrested with several charges, and he was convicted in 2013. It was a very hard conviction. There were some very hard charges, and in 2015, the Italian Supreme Court rejected the appeal. As it appeared in previous cases, and I would like very much you to focus on this point, it's very rare that in this case just one country is concerned. All these cases are in principle transnationals. That is the consequence of the market. We come back to this point that I consider extremely relevant. And of course, when we think about the fact that these crimes are transnational, we could draw some consequences from them, from this statement. And some consequences belong to the need for judicial cooperation, the need for strengthening this judicial cooperation and police cooperation, but they also highlight some obstacles in prosecuting these cases. Of course, this is a more legal issue I will try to focus on later, but please be aware that these kind of issues, as already Christos said in his presentation, have this transnational dimension. Well, the last case I was presenting in these slides, and I will shortly mention here, under this very vague etiquette of emerging crimes. This is not my etiquette or label. This is how the United Nations used to call crimes in the era of art and antiquities.
Scusa Stefano,
yeah.
Interrompo. La slide che noi vediamo è sempre quella iniziale, è corretto così oppure c'è qualche...
Ah no, scusami, io sto andando avanti, ma evidentemente...
Ok, adesso sì, adesso è passata a una delle successive. Ok.
Chiedo scusa, io stavo scorrendo, ma evidentemente nella presentazione non si vedeva.
Adesso scorre, ok, grazie mille.
Sorry for not being so good in using my PowerPoint presentation. Sorry for that. The previous slides had some, probably didn't see them, but I was actually commenting on them, and I was actually giving some elements to you. So unfortunately, you didn't see them. One was the Stefano Bronze. I will now come to this destruction of Timbuktu. Of course, we are dealing with a very different kind of crime. We are in the same area. I hope you can see, Alessandro, right now, the slide. Can you confirm that, please?
Sì, adesso.
Thank you so much. So, of course, what I've been dealing with until now was a certain number of crimes relating to movable cultural property, either antiquities or pieces of art. Here, I will just mention very briefly another case. As you can see, I'm not just dealing with, theoretical cases. They are all concrete ones. And the ones I'm most interested on are the cases where a judicial decision took place. This is again a case that I consider extremely relevant, and this is the so-called Almadi case or Timbuktu case. You may be aware that in 2011-2012, a very violent civil war took place in Mali. And in this context, one of the factions fighting in Mali decided to attack and destroy the 10 temples situated in a very famous and the whole place of Timbuktu. Behind this decision, there were of course some strategic reasons, but also for some symbolic reasons. The idea underlying this attack is that the faction, let's say, wanted to give a very strong sign against the religious opponents, and they wanted to destroy the temple. Let me show you the picture. There was before and after the destruction, and it was one of the 10 temples which have been totally ruined during this attack. Because of this attack, this person you see here with other participants to the crime has been brought in front of the International Criminal Court, and he has been held responsible for war crimes in this area. He has been adjudicated in September 2016 to 9-year prisons for committing a war crime by deliberately destroying 9 mausoleums and the secret gate of the Sayyidia Yahya Mosque. Once again, I don't want to give you details about the case. I'm not able today to comment on every single decision. This is not my aim today. It was just to give you a very rough and general overview on how broad could be these kind of crimes and which are the elements they encompass. Once again, we have here an international element, which is not a transnational, but international in the sense that the international community showed an interest and brought this individual and some others in front of the justice. Well, could we actually draw some very preliminary conclusions for what I was mentioning until now? Well, if we wanted to have a list of the kind of offenses relevant in this area, that list would be extremely long. Theft, illicit confiscation, forgery, illicit excavation, pillage, vandalism, destruction, and of course, illicit trade and export. I would actually say export and import, money laundering, tax fraud. Well, why I'm mentioning these elements? Because I think they will become important when we will comment on the international legal texts, and we will see under which focus they have been dealing with these topics. From the criminological point of view, we can also add some other points. Every single point which is stated in this slide, it could be followed by, let's say, a question or some specification. Is that organized crime? Is that white-collar crime? Is that transnational crime? Is that related to terrorism and war crimes? Well, probably the answer is yes, even if, of course, depending on what you choose as a focus of your criminal law approach, the responses can vary. Well, first of all, is that organized crime? As you say, I have a question. This is a question that we have been discussing for years at the international level. Is there a mafia, let's say, involvement, other mafia organization involved in that? There are, of course, a certain number of cases. But let me say that in my own view, even if these kind of cases do not rely on the individual perpetratorship, but they always have a certain number of corporate perpetrators or accomplices, it's very difficult to, let's say, to include them in the notion of organized crime, unless you use a very broad notion I will mention that later, because there was one of the approaches which has been chosen by the United Nations, and I'm not sure there was the most appropriate one. The second point is that a white-collar crime? So is that an economic crime? Well, there is no doubt that the crimes we are discussing about, they bring very high profits. And in this arena, there are a lot of corporate actors, museums, dealers, auction houses, collectors. I think that this second approach could be very relevant in tackling the phenomena, and we will see to which extent international legal texts have taken that into account. As I mentioned previously, most of these crimes are transnational. One of the reasons is also that e-commerce and internet are a very important platform, as most of the investigators know. And last but not the least, some of these crimes are connected to terrorism or war crimes. The very last example I gave to you is a clear explanation of what it can happen. Sorry for that, I went too fast. Well, the next three slides show something that criminologists have, or criminology has deeply analyzed, something again that is very important in order to define criminal responses. We have at least 3 different kinds of countries, what we call source countries, what we call market countries, and what we call transit countries. Of course, it's very difficult to say that every single state just belongs to one of these categories. Sometimes a state can be both a source country and a market one. But there are some clear examples. Source countries, well, there are, of course, the countries where they have the most relevant cultural heritage. They try to defend, in terms of criminal law, their position by having quite a strong reaction to that. When you look at the opposite side, so market countries, of course, United States is a very good example for that. The legal framework is not always that important because there is not this awareness on the relevance of cultural heritage, and because, of course, economic actors actually have a very strong activity in their jurisdiction. And if we want to mention transit countries, and I think that the example of Switzerland could be a very good example, as Christos mentioned before, some of the pieces of art and antiquities have been found in Geneva, at the free port of Geneva, and this is something we could comment, but I won't do that. Well, we observe in a certain number of transit countries an evolving dimension of criminal law. So I'm aware that these kind of elements are very rough. They are probably more useful for students than for colleagues. There are a certain number of legal analysis going in more deeper details. So let me come in the remaining time it's allowed to me today on the international legal framework. And let me show in this slide how complex is the interplay of international institutions in this arena. I mention here just the main ones. Interpol, of course, with a special support. United Nations with 2 agencies, UNESCO and the UNODC, the World Customs Organization, the International Criminal Court and other international tribunals, UNIDROIT, which is an entity dealing with harmonization and unification of private law, ICOM, and some regional entities, like in particular Council of Europe and European Union. This is just to say to you that in the last, I will actually say, 50 years, as we will see together, there is an evolving international legal framework at the demand of one or more of these international institutions. Unfortunately, the legal framework is very fragmented, is not very well structured, and as I mentioned before, it is quite poor in terms of criminal law responses, except for some of the most recent elements. Well, even if the additional slide is showing to you in deeper details the most relevant international legal texts one has to keep in mind when dealing with this area. Some of them belong to the what is called international humanitarian law, so they reflect the need of a protection of cultural heritage during conflicts. You can see that the Hague Convention, the Geneva Conventions, the two protocols to the Geneva Convention and to the Hague Convention, and the International Criminal Court stated, they all relate to what I would call, in a very rough manner, war crimes. Please forgive me, even if they are presented in my slides, I will not deal with them here. And then you have a second list of conventions. The most known is the UNESCO conventions on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property, which has been adopted in Paris in 1970. As everybody knows in this area, this is the most relevant piece of legislation up to now. I also mentioned some other international texts arising from the United Nations, like, for instance, the UNODC guidelines. And last but not the least, at the bottom of the page, you have the Council of Europe Convention on offenses relating to cultural property, adopted in Nicosia in 2017. Well, what is my aim in the next presentation? As I said to you, I won't deal with international legal framework referring to war crime. So even if you will find here some slides and some details, due to the lack of time, I don't think it would be wise to comment on them. Well, let me come to the very relevant piece of legislation, which is the UNESCO Convention adopted in Paris in 1970. Well, actually, I have to say, and I will be very direct and honest about that, this is a very useful instrument for restitution of cultural property when it has been illicitly imported, exported, or transferred. But from the criminal law point of view, this convention doesn't say anything. This is clearly showing how in the 70s, well, return and restitution were at stake. I agree that for most of the antiquities we were dealing with, this is a very important issue. But if you look at them, if you look at the provisions of this convention with the let's say with the lenses of criminal lawyer, you won't find anything important. Just to give you a very clear example, state parties in Article 7 undertake to take the necessary measures consistent with national legislation to prevent museums from acquiring cultural property which has been illegally exported. So they should prevent museums. Should they punish them? Well, look at Article 8. State parties to this convention undertake to impose penalties or administrative sanctions or on any person responsible for infringing the prohibition refers to Articles 6 and 7, so import and export in an illicit manner. But you can easily see that penalty or administrative sanctions are not the same. So that leaves room to any signatory entity either to adopt a penal or a criminal law approach or an administrative one. This is a clear sign of how the international community has been dealing with this issue for decades. Well, 20 years later, in Havana, in Cuba, the United Nations tried to adopt a model treaty. And since I say they tried to adopt, I want to explain to you. Well, 3 model treaties were adopted, but the one which was not approved was exactly this one. And there was the one related to the movable cultural property. This is an important piece of legislation, but it's not binding at all. So unfortunately, even if we find a certain number of details related to how to prosecute criminally these kind of crimes, the consequence of this not binding instrument is zero, is nothing. I have to be so a little bit rude in my statement, and I won't hurt anybody in saying that. I think the effort was extremely important. The result was amazing in terms of drafting a text, but the concrete result from the legal point of view in terms of criminalizing these offenses was again zero. Well, I will devote my efforts to 2 texts. One I'm responsible for, and the other one, which is the Nicosia Convention, that I think is the most relevant one in terms of criminal law approach. Why I say that for the first one I'm responsible for. What I'm commenting here, and I hope you see my slides, otherwise it won't be easy to follow me, is what has been called the UNODC guidelines. Please, for the sake of clarity, note that UNODC is a specialized United Nations agency concerned with the fight against crimes and drug trafficking. Well, let me also add that within the United Nations, there are 2 agencies which are interested in fighting against these crimes. One is UNODC, the other one is UNESCO, of course. Well, these UNODC guidelines relate to the crime prevention and criminal justice responses with respect to trafficking in cultural property and other related offenses. Please note how late they have been adopted. They have been adopted in a General Assembly resolution in 2014. And just to clarify why I said that I am responsible for them, I was in fact the person who was being consulted by UNODC in order to draft these guidelines. It was an impressive work I did with some other colleagues. I'm very grateful for. I will show to you some of the main features of these guidelines. Once again, please be aware that they are not drafting as any single guidelines. They were addressed to member states, but they had not, let's say, a compelling force, and they were not obliging states to criminalize these conducts. Nevertheless, they had a very strong impact on the international debate, and the fact that they were adopted by the General Assembly in a resolution gave them a paranormative power and strength. Well, just looking very briefly at them, you can see that the guidelines represent a useful framework to guide member states in developing and strengthening their criminal justice policies, strategies, legislations, and cooperation mechanisms. So what I want to stress here is that for the first time, criminal law is at stake. Of course, I don't ignore that in many domestic legislation of criminal offenses already exist, but this effort was unfortunately challenged by the fact that in many other countries, these pieces of legislation either did not exist or they were not applied. Well, member states are strongly encouraged to evaluate and review their legislation and legal principles, procedures, policies, programs, and practices. They have to adopt prevention strategies this is, of course, extremely important in order to collect information, inventories, databases, registers. They should consider having statistics. They should consider having national databases. And this is, of course, also relevant in terms of enforcement, as we will see in 1 minute. The second chapter of these guidelines relates to criminal justice policies. Every single state is asked to criminalize the conduct of trafficking in cultural property and to use the model treaty in bilateral cooperation. And they have to criminalize a certain number of serious offenses which are listed here: trafficking, illicit export, illicit import, theft, looting, conspiracy, money laundering. Maybe I would just to mention a couple of points, additional points. One relates to the mens rea, one of the most complex issues at stake when you deal with international dealers. How do you prove in front of a criminal judge that a museum or auction houses has the actual knowledge of the illicit provenance? Well, this is something we will be eventually able to discuss in our in the Q&A. Member states have to adopt proportionate, effective, and dissuasive sanctions, and they have to introduce liability for corporations or legal entities. Well, most of the colleagues who are attending the event today are totally aware what I'm talking about. Is not enough in an area where economic entities, private entities are strongly involved in, just to deal with individuals. So the need arose in 2014 to include legal persons, let's say again, museum, auction houses, collectioners, any private organization that could be actually involved in one of these offenses. The need arose to include them among the addressees of criminal law provisions. Well, I don't want to say more about that, even if, of course, these guidelines include so many elements that we should actually take a long time just to go in deeper details. And I will actually try to make a step further. And the step further will be my last one. Alessandro, do you have 5 more minutes? No more than that?
Of course.
Thank you so much. Thank you. Well, I'm now coming to the very last piece of international legislation in this area. Let me say that I'm strongly convinced that the UNODC guidelines paved the way for a more, let's say, integrated criminal law approach at the international level. If we look behind us, if you look at the tools adopted in the 70s and at the attempts which have been made in the 90s, unfortunately, nothing relevant or binding was made in terms of strengthening criminal law responses. But the first step has been accomplished with the UNODC guidelines. I didn't mention to you that they were very much oriented in terms of fighting organized crime due to the special interest the UNODC has in this area. But without commenting on this point, we had to wait until 2017, so only 3 years ago, in order to have the first signed treaty. And this treaty is the Council of Europe Convention of 2017. Look at this slide. There are some signatures, not that many, and there are just two ratifications. Of course, source countries. But that means that we are just moving the first steps in this area. And when I say European conventions, I could actually mention some other legal tools arising from the European Union, but unfortunately, they have no criminal law content. Well, the Council of Europe Convention is a very important piece of legislation in this area. It's the only one dealing expressly with a certain number of criminal offenses and defining them. I say that just for the sake of clarity with the students. This text has to be implemented through national legislation in our legal orders. Without legal transpositions, this text will not be binding for individuals. So this is so obvious, but it's of course something that is relevant in our discourse today. So just look at the slides and the following one: unlawful excavation and removal, illegal exportation, illegal importation, acquisition, placing on the market, falsification of documents. Well, I didn't mention all the offenses which have been drafted here. Just let me show to you that for the very first time, and the difference is really striking when compared to the UNESCO Convention of the 1970, we do have a definition of offenses. We don't have a vague reference to theft or illicit exportation or importation. We have a definition. We have something that is relevant for our criminal law legislation. Some of these offenses could be criticized. Some of them are extremely complex. How we could define the notion of placing on the market. This is something that we could extensively discuss with the colleagues. But please accept my apologize for not being able today to go into deeper detail and giving you just this very short and brief overview. Well, liability of legal persons comes at stake. That was essential. We said that in 2014. It was, of course, shared by many legal experts, and we are happy to see here that for the first time, these kind of offenses are dealt with as they were white-collar offenses. They are made for profit. Private entities are responsible for them. We have to include corporate criminal liability in this arena. Sanctions and measures. Well, for the first time, we don't just see the same formula we had in 2014, the DC guidelines, effective, proportionate, and dissuasive sanctions, but we also have a very explicit request. This offense should include deprivation of liberty that may give rise to extradition. We want to prosecute this crime effectively. Legal persons are exposed to disqualifications, exclusion for public benefits, judicial supervision, and of course, very importantly, in this Article 14, paragraph 3, seizure and confiscation must be allowed. I don't want to give you more details, but you must be aware that in the very first case I was mentioned here, the Fano state or the youth state in a Paul Getty museum, the issue of confiscation was the most relevant one. Well, I want to come to my conclusion. My conclusion is that for the first time, the international legal framework has been, is evolving in my view in the right direction. There will be the need for more effort to be done at the national level. I was myself part of the preparatory work in Italy for the reform. Unfortunately, we still have a draft pending in front of the parliament. The draft was a little bit unbalanced, in my opinion. I made some commentaries on that in front of the House, in front of the Parliament, and some of them have been accepted. We have now a draft, an amended drafted. My very last conclusion is that we have a very wide literature in this area. Myself, I was responsible for a certain number of collective researches and publications, and some of them have been made public to you through some links that I provided to the organizers of this meeting. Last word is just to thank you for your attention, and I'm of course available for any query you could have. Thank you so much.
Thank you, Stefano, for this really impressive overview in the chronological, criminalization, and legal aspects of illegal trafficking from and cultural heritage from an international, global point of view. Thank you, most of all, for showing us how complicated international international law on this matter is, and how in this complicated set of norms is reflected the different approach that different states may have in the criminalization of this kind of offenses. I was particularly impressed by your comparison between three different kinds of possible approaches by states: source states, market states, and transit states, which probably is reflected in some norms, for instance, norms that can be found in the Nicosia Convention. If you think to Articles 4 and 5, if I remember correctly, criminalizing unlawful excavation and illegal importation, these norms admit the possibility for states to reserve the right to provide for non-criminal
administrative sanctions. Absolutely. Yeah, it's true.
Which perfectly reflects what you were saying. Saying about the different possible approaches to this matter. So thank you very much for your lecture. So now we have our 5-minute stop, and then we will go on with a different lecture. So see you at 5:05.
See you later.
Okay, welcome back. I think we are ready to listen to the presentation by Dr. Federica Lachioma, to whom I give the floor. Please.
Thank you, and thank you for inviting me. It's a pleasure for me to be here again with you after the last seminar that we did last year, although in a different format. And I'm very happy to meet again Mr. Georgianis, that I met during an interesting course in France, and they introduced me to the forensic archaeology, which is very interesting. And I'm going to talk to you about a case that we dealt with Professor Giannis in Lyon, and that I happen to find being very close to my jurisdiction, my area of competence, because we are going to examine thoroughly the case of Gianfranco Becchina. And Gianfranco Becchina has been known as a trafficker of cultural properties, of looted objects, and we can say that he was a trafficker as he was stated, such as in final verdict that was released on him by the judge of preliminary investigation in Rome, although the crime was considered extincted because of the time lapse for the exercise of the criminal action. And Gianfranco Becchina is a man coming from Castelvetrano, so he's very close to our area, and that's the reason why I decided to introduce you to this case, because it's very interesting, and because we are through analyzing his criminal and judicial history, we can examine different aspects and tools of the criminal instruments that can be used to fight the trafficking of looted objects and the trafficking of cultural objects and archaeological objects. And the Becchina case dates back to the 1990s, as the trial started in 1995 with the first report of the financial unit, Guardia di Finanza, that made a report on the properties of Becchina. And Giovanni Franco Becchina, also said as Gianfranco Becchina, is officially an art dealer who was born in Castelvetrano. And his job didn't start as art dealer, because he was an entrepreneur who was first declared bankruptcy in 1979. And after the bankruptcy of his company, he started to travel and to move to Switzerland, where he started to set up different companies and to be involved in the work of art dealing with his wife, that was Ursula Marie Juraszek, that was, as I said, his wife, and was the owner of a gallery, Antiche Kunst Gallery in Basel, where they started to deal with art. He was not the owner of the gallery, but still worked with his wife. And as I said, in 1995, the financial unit, the Guardia di Finanza, started to investigate on him, and because he had been found with a lot of looted objects that were available to him and that were found available to his wife, because there was a rogatory letter that was sent from Italy to Switzerland, and the Swiss authorities started to investigate on him, Becchina himself, and his wife, who was actually arrested and started to cooperate with the police in Switzerland, so started to make some statements against his wife. So the trial officially started, and the trial was enrolled, registered as number 40636 in 2001. And I'm highlighting these the numbers and the data because they are essential to understand the story of the trial, which has been a story that lasted for almost 30 years, and in considering this long story, we have to take into account also the position of Becchina, who claimed to be prosecutors for more than 30 years for his activities as an art dealer or an art trafficker. We are going to assess what is at the end of my presentation. So the case was registered in 2001, and the criminal prosecutor in Rome started to make his investigation on Becchina because of the property that he had collected and sold throughout Italy and throughout Europe, because he made a lot of purchases and exchanges with other countries. So the public prosecutor in Rome accused Becchina of different crimes. When we come to the indictment of Becchina, we see that he was first accused of criminal association, and this is very important because we have to take into account that in order to fight the illicit trafficking of cultural properties, we cannot have an atomistic approach trying to follow the single object, but we have to take into account that we are often dealing with a network of experts. And if we are going to, as we are going to do, if we look through the judgment, the final judgment that was released at the end of Becchina case, we will see that the judge examines all the network of Becchina, which was not made by Becchina himself. Becchina was just a chain, was just a ring of the chain, but actually the network is made of dealer, looters, middlemen, companies, galleries, auction houses, experts, professors, scholars, a huge network, members of which were named into the final judgment. So the final judgment is very interesting to read because it describes an environment of people. Some of them were very wealthy people and prestigious people working into academies, into galleries, into museums. That are the people that were the main characters of the artistic life of Europe and outside Europe, because the trade of Becchina reached also Australia and Japan from 1970s until 2000. So it's very interesting to read the case because you can see how the indictment of criminal association was built upon the connection that were found among the defendants. Becchina was the only one who was prosecuted by the Rome prosecutor officers, but still the judge describes the criminal association, naming the people who were part of this group. And as you know, the criminal association needs to be aimed at a purpose. And the purpose of this criminal association, this alleged criminal association, was to commit the crimes of illegal receiving of looted objects. So Article 648 of our criminal code, and the illegal trade of diluted objects that belong to Italian cultural heritage. That is Article 87 and 125 of the Code of Archaeological and Environmental Heritage that was enacted in 1999. So actually Becchina was accused of being a member of a criminal association, which at that stage was not a mafia association, was just a criminal association that was aimed at illegal receiving and illegal trading or trafficking cultural properties that belong to the Italian state. And he was also accused of counterfeiting documents because, as you know, the code of the cultural and environmental heritage of the Italian state not only prescribe things, not only impose criminal sanctions, but also prescribe some behavior to the owner of the or the custodies of the cultural goods, for example, to make statements, to make declaration to the state where the goods are collected or where the goods are exported. And it came out from the verdict and from the investigation that Mekina did not report the information about the looted objects, or on the other side, he made fake declaration that was found fake. So it was accused only of violating Article 483 of the Italian criminal code. And the crime was considered, were considered to be committed in Rome, because the activity of Mekina was based in Italy according to the provenance of the cultural goods that were coming from southern Italy, but also from Greece and other parts of the Mediterranean area, but was also considered the crime to have been committed outside Italy, because at that stage, we are speaking about 2001, it was a true transnational crime, as we intend it now, because it had been committed with the contribution of people outside Italy, but the jurisdiction was rooted in Italy, because part of the behavior or the final event took part in Italy. So this was the reason why Italy took to jurisdiction. Also because we had evidence from the verdict that the trade of the goods took place in Italy, and it was one of the evidence that the judge analyzed and highlighted to demonstrate that actually there was a criminal association involving also the museum, because an important evidence of the creation of a network was that the some directors of museum were considered to have traded directly with Mekina, and we have evidence of that because we have correspondence and letters, even though they figure to make agreements with the art galleries that Mekina had in Switzerland. So what the judge of preliminary hearing stressed is that if we have evidence that there were direct contacts between director of galleries in the United States and Mekina in Italy, proving that they had connection, they had links, and they had exchanges of information, we have to consider that the exchange that took part, that happened through the galleries of Mekina were just fake, because the art galleries worked just as middlemen for the negotiations that actually took part just between the private investor Mekina and the art galleries and in museums in the United States. And when I speak about the final judgment, I am speaking about the final judgment that was released by the preliminary, the judge of the preliminary investigation. Because what happened during that case is that, as I said, the case was registered in 2001 by the prosecution office in Rome, but in October 27 of October 2001, Mekina was subjected to a decree of the public criminal prosecutor, decree of custody of suspect, which is what we call fermo di iniziato di delitto according to Article 384 of the criminal code. So it was put into custody without the intervention of the judge of the preliminary investigation, only according to the decree of the public prosecutor, who considered that Mekina was a suspect of the crime mentioned above, which is criminal association, illicit trade, illicit receiving, recycling of cultural properties, and it was subjected to custody, and the the decree of the public prosecutor was issued because there was a high risk of escaping the country, because Becchina was considered to have connection with Switzerland. Actually, he had a Swiss wife and a wife based in Switzerland, and he had his art galleries in Switzerland. He had this contact with people in northern Italy and in Switzerland, and there were wiretappings that he was having contact with people trying to recover the assets that were at high risk of seizure. So the public prosecutor decided to issue a decree of custody of suspect of crime, fermo di iniziato di delitto, because there was the high risk of the suspect to leave the country. So it was subjected to the pre-trial custody because the decree of the public prosecutor was convalidated by the judge of the judge of the preliminary investigation in Rome. Actually, Becchina was subjected to the decree in Milan because when the fermo di iniziato di delitto was executed, Becchina was in Milan, but then the judge of preliminary investigation decided to convalidate Milan because Milan was the place where the decree was executed, and then it was, according to Article 27 of the Criminal Procedural Code statute, was sent to the judge of preliminary investigation in Rome to be convalidated because the crime was rooted in Rome, and the judge of the preliminary investigation convalidated the decree of the public prosecutor and put Becchina into custody, into pretrial custody, because of the allegation that I said before. And actually, the case of Becchina kept on, and it actually ended to the preliminary hearing. And when the case went to the preliminary hearing, the crime of association, of criminal association, was sent to the trial, but the other crimes that were minor offenses, or for example the illegal trade, but other offenses like illegal receiving, had been considered already prescribed, prescritte, because of prescrizione, because there had been the time lapse for the exercise of the criminal action. So Becchina was acquitted for these minor offenses, while he was sent to a trial for the only crime of criminal association. And the final judgment of for the enactment of criminal association came about 10 years later, and it ended up with an acquittal, because also in that case the time had passed, so there was no more time to exercise the criminal action, and the judge were forced to state that prescrizione had come. So it was acquitted once again also for criminal association. Nevertheless, when the judge, in particular the judge of preliminary investigation, declared that there had been a time lapse for the minor offenses like illegal trade and illegal receiving of looted objects, nevertheless, the judge of preliminary investigation had to, the preliminary hearing, had to state about the fact that whether Becchina had or not committed the fact, even though that fact couldn't be punished because of the time lapse. And ascertaining whether or not Becchina had committed the facts was necessary in order to state about the properties that had been seized during that years, because according to rogatory letters to Switzerland, the Italian authorities had gained the cooperation of the Swiss authorities, that not only interrogated witnesses and arrested people and made search warrants and executed search warrants and seizure warrants, but they also delivered cultural properties seized to Becchina to Italy. So it was necessary for the judge of the preliminary hearing not only to state or not whether the crime could be punished, but also to ascertain whether the fact had been committed, because it was necessary in order to dispose of the goods. Because if you look through the judgment, you will find more than something like 17,000 documents and several thousands of objects that had been found in the properties of Becchina. And it is interesting under this point of view that this part of the final judgment arrived until the Supreme Court that were called to state about the property of these cultural goods that had been seized by the Italian state, and that had been towards Becchina, who had been acquitted from the judge, because there was an appeal to the Supreme Court by the wife of Becchina, because actually this property didn't belong to Becchina, because Becchina was not the owner of the gallery that was located in Switzerland. The true owner was the wife, even if we know that she was just a middleman, a fake owner, a counterfeited owner, a deceived owner. So the wife of Becchina appealed towards the final judgment in order to take back the property, to have back the properties, but the Italian Supreme Court stated that the properties, even if Becchina had been acquitted, couldn't be restituted to him because the fact of having traded cultural properties that belong to the state, because the cultural property belongs to the Italian state, was sufficient to confiscate the asset that needed to be given to the Italian state, because actually the property belongs to the Italian state since the law of 1939 that stated that all the cultural objects belong to the Italian state. And moreover, the Supreme Court stated that in these cases, according to Article 240 of the Italian Criminal Code, the confiscation needs to be executed unless it regards goods that are properties of a third party to the case. And according to the Supreme Court, even if the wife of Becchina is not the defendant, still she needed to be considered she couldn't be considered a third party to the case, because actually the verdict of the judge of preliminary hearing, still declaring that the prescription had occurred, still it examined all the facts and found out that Becchina's wife had been involved in the general network, and as I said before, so she couldn't be considered a third party to the case. So the confiscation could take place even to that extent towards the goods that she was the owner of, because she was not a true third party to the case, but actually she had been involved and had some links to the crimes. And the Supreme Court said that in this case, the link to the crime is essential to subject the goods to the confiscation. So this is how the properties, the cultural objects, the looted goods that had been found by Becchina in Italy and in Switzerland were restituted to Italy. And we need to highlight that some goods were recognized as property of the state. They had to be restituted to Italy, but actually they hadn't been delivered to Italy, because the Switzerland authority searched and seized some of them that goods, but didn't deliver it to Italy. So In his final judgment, the judge stated that in order to give execution to this duty of restitution, another letter, rogatory letter, had to be sent to Switzerland in order to have the properties of Becchina confiscated to Italy sent to Italy again and actually confiscated and restituted to the Italian state. As I said before, the verdict, the final judgment of the judge of preliminary hearing was very interesting because it depicted all the links between the people that were involved in this history. And what is interesting is that the judge of preliminary hearing recognized that what features this group of people as a criminal association is that they resorted always to the same scheme, always to the same people, always to the same crimes. So it was a consolidated model that was not isolated, and it was evidence of a long-term agreement that was essential to gain the property of the cultural object, which was at the advantage of every member of this network. And the judge of the preliminary hearing recognized in every participant to this criminal association a specific role and specific identity, because we have evidence. And I want to stress the fact that, as Christos said before, there was a panel of experts that were appointed, and they were appointed in order to examine all the cultural and archaeological goods that had been found through the seizure warrants. What is interesting is that after the fermo in the indicato di delitto, the criminal prosecutor asked for the preliminary hearing, and it was during the preliminary hearing that the panel of experts was appointed through the form of incidente probatorio. So incidente probatorio, which is the preliminary appointment of panel of experts, took place during the preliminary hearing that took a long time because it was necessary to analyze the large amount of looted objects, and the panel of experts were called to answer to were called to sorry, I was being phoned. They were called to answer for some main questions. First of all, they had to recognize the provenance of the, or at least try to recognize the provenance of the looted objects, and to assess whether they were authentic or not. So the main issues that the panel of experts were called to answer were whether these goods were authentic goods or they had been counterfeited, and on the large amount of thousands of objects, just few of them were recognized as fake. So it demonstrates how massive was the illicit trade by Becchina as in his partners, and they were called to ascertain whether where this looted object came from. And this is very interesting to find in the final judgment, that you have a list of single objects and an explanation of the objects that were recognized as coming from one part of Italy to the other, which is very interesting to read in terms of cultural explanation of the provenance of the object. But at the same time, this is very interesting from a criminal point of view, because the idea is that you can see from the judgment, and it's very clear that every region of Italy had got its looters, so people that were a reference point for the excavating of cultural sites in every region. So Becchina, even though he was rooted in Sicily, had contact with people, for example, Raffaele Monticelli in Apulia, Vincenzo Camarata in Sicily, Pietro Mocci in Sardinia, and so on and so forth for every region of Italy. And the final judgment refers to the a note that was found by the house of one of these looters. That was a scheme, that was the one that you saw in one of the slides of Christos, that described the network with single partners from every part of Italy, because every looter had got his reference zone in Italy. So Becchina was the collector between all these looters and the dealers of the goods. So Becchina acted truly as a middleman together with Medici, because Medici and Becchina were the main middlemen that negotiated these goods that were excavated and digged in Italy, and they made their purchase possible. Because what you have to consider, and the judge of the preliminary investigation recognized that, is that it was impossible for Becchina to sell directly one of these looted objects, because as you can imagine, a looted object had no price, because actually it was out of market because of its high value, and there was the problem of creating a traceability of the object, because the object couldn't be sent to market because it didn't have a legal provenance. It had an illegal provenance. So what Becchina did was to collect this object from the looters, and instead of sending them and selling them to museum, selling them to his private art galleries, the one that was based in Basil, the Antiche Conspalladium, the gallery that belonged to his wife, that created a fake documentation, a counterfeit documentation, stating that the document, the good, came from, for example, a private collection. So in this way, the gallery of Becchina and some other galleries, for example, the Atlantis Antiquities in New York, that is another art gallery of such genre, they acted like clearing houses, because they gave the title of legitimacy to a good that had an illegal provenance. So these galleries work as a recycling mechanism that created a fake passport to the document that could be presented to the market as being purchased by private collectors and being exhibited by private galleries. So the network started again, because through these private galleries, for example, the Antiche Conspalladium, the illicitly traded goods could be sold again to Becchina himself, so that he can sell them privately with the price, the high price on the market, or were sold to other museums. But as the professor said before, there was the mens rea of these. There was often the mens rea of these museums, because we have evidence, and this is what the judge of preliminary hearing stressed, that we have often direct contact between the director of museums, for example, for Getty Museums, through the director Marion True, as Christos recalled before, that had direct links, direct letters, exchange of messages with Becchina. So the judge of preliminary hearing simply says, if the purchase took place between Paul Getty Museum and the Antiche Conspalladium in Basilea, what's the point in writing private message between Marion True and Becchina? Probably because the Conspalladium and the Paul Getty Museum worked just as the fake parts of the counterfeited parts of these contracts, but the agreement was made between two parties who were well aware of the role that each other plays in this exchange, in this agreement and negotiation. So it was a clear scheme, and of course, to this scheme, there were other people took part, because you need to consider that Becchina was not an expert, as I said before. He started as a private entrepreneur, so then he happened to have a cement company in southern Italy, so he didn't have a background as an artist or as an archaeologist. So what was necessary once he collected the looted object is, first of all, he needed to expert to restore the object, because as Christoph said before, a lot of objects were damaged or broken or soiled. So he needed to have the help of professionals who could help with the restoration. And of course, since they were experts, they were conscious of the illegal provenance of the properties. Also because the properties were the looted objects were brought to them in bad conditions, so it could be easily conceived that they had been just digged from archaeological sites. And then, apart from the experts in restoring, the network needed some experts in analyzing the looted objects. So we have evidence, and this is you can read it through the judgment of the judge of preliminary hearing. There is a long history of professors and scholars and professors in university that contributed to the study of the properties that were sent to that were sold by Becchina to the museums. Because once you can imagine that once Becchina sold the looted objects to the art galleries, and then the art galleries has to offer it to to, for example, a museum in Japan, in Australia, or the United States, they had to present the object, and a lot of time a contribution in this text to this extent came from a professor of university who took part to this project, this criminal project to Becchina. So it's very interesting to read through the final judgment, because it builds again all this network of people belonging to different environments, so arts, crime, universities, galleries, museum, who contributed and had beneficial effects, each one for his own, from this illegal trade. And when we come to the beneficial effect for every member of this network, you can consider in particular, it's important, it's curious in particular to imagine which were the benefits for Becchina. Of course, he became a millionaire, and one of the witnesses stated that Becchina and Medici didn't have an economic background, but still through their activities they became one of the biggest millionaires in Italy. And the public prosecution office in Palermo, in particular, started to investigate which could have been the beneficial effect for Becchina to trade in arts, and the investigation started. That was finally dismissed. So we are speaking about an accusation that has been dismissed by the Palermo judge of preliminary investigation. But still, it's important to know that Becchina started to be investigated because there was the idea that he could be linked to criminal association, and that this illicit trade of cultural properties could have been beneficial to the mafia association in Sicily, because they could, for example, the money coming from the profits of this illicit trade could be beneficial for example, for people in jail, because you know that people in jail need to be maintained by the criminal association, or in general, for example, to buy arms for the criminal association. It's important to know that this was an hypothesis that you can find in the newspapers. There are still traces, tracks in the newspaper of this proceeding against Becchina, but you have to know that even in this case there was no legal action, because no exercise of criminal action, because the case was dismissed upon request of the criminal prosecutor himself, who said that the elements were not sufficient to bring Becchina into court for this indictment of criminal association, specific mafia association. But still, the story of Becchina is not ended, because, as you can see, and this is the reason why I'm speaking about this, because it's something that is public, because it's on the newspaper. Becchina was again part of a proceeding, but it became part not of a criminal proceeding, because so far we have spoken about a criminal proceeding, criminal file. The state found another way to hit Becchina, this time not through criminal proceeding, but through prevention proceeding, through a proceeding of misure di prevenzione. And you can find in the newspaper, and I gave you as a material a press release of the DIA, Direzione Investigativa Antimafia, that seizure, so they executed a seizure decree, sequestro preventivo, of a lot of goods and properties of Becchina as a prevention measure. The prevention measure is a different instrument that is used, and the requirements are different from the criminal case, because in the case of a criminal proceeding, you can seize an asset if you have evidence that a crime has been committed, and you confiscate the assets if you have evidence that the crime has been committed. In the case of prevention measure, you can seizure the assets if you have hints that do not reach the criteria of the evidence that a person is dangerous. So if he has got a dangerous lifestyle, of course, as we said, Becchina was first declared bankrupt, then he was acquitted, but he was involved in a proceeding for illicit trade of arts. Then he was accused, even though the case was dismissed, of criminal association. So, of course, there was a lifestyle that was evidence of a certain dangerous nature of the lifestyle of Becchina. And then, if the property that you are going to seizure are disproportionate to your lifestyle. And in this case, different from what happens in the criminal case, while in the criminal case, it is the public prosecutor who have to prove that the illicit origin of the goods that he wants to confiscate. In the case of the prevention measure, there is a reversal of the burden of proof. So it's the duty of the accused person in the prevention measures to prove that even though the properties look disproportionate to his incoming, still they have illicit origin. So in this case, it's the duty of the person under the prevention measure proceeding to prove that all these properties, and in this case we are speaking about a lot of objects, a lot, for example, of castles, a lot of goods, have got illicit origin. And of course, it's very difficult to prove the illicit origin of a good, because either it can come from an inheritance, or it can come from illicit purchase. But in any case, it's still the responsibility of the person under proceeding to prove. So to me, it's a very interesting perspective, because even though the case has not concluded yet, we don't know how it's going to end, and it can be possible that the seizure will be dismissed and the good will be restituted. Still, according to me, it's very interesting, because it gives us another tool to fight against illicit trade of cultural properties. And because apart from the criminal case, the criminal proceeding that often end up with an acquittal because of procedural reasons, for example, the time lapse for the exercise of criminal action, the prevention measure is very useful, because sometimes it can prevent some difficulties that you have during the criminal trial, and also because it's useful to prove the danger of the people involved in the proceeding. And when we come to danger, we have to consider that in this case, even if Becchina was accused only of illicit receiving of looted objects or illicit trading of looted objects, we are not speaking just about of property. As the professor said before, we are not speaking just about property, we are speaking about cultural identity, because what comes very clearly out from the final judgment of the judge of preliminary hearing in Rome is that, for example, in order to excavate one object, 10 different sites had to be, archaeological sites had to be digged by the looters. So you can understand from this how big was the effect of the excavation that were made to find this illicit object, and now this the activity of the looters devastated the country, the cultural heritage of our country, because they impeded for the rest of the life the possibility, the chance to study the object in situ, because as it's very clear from the final verdict, since the looters didn't have the technique for studying the sites, a lot of sites collapsed, for example tombs, so a lot of objects were completely damaged, and a lot of sites were completely damaged. So the damage was not only to the property, it was a damage to an identity, the identity of the country, and it's perfectly, even if on a national basis, it's perfectly consistent with what the International Tribunal, as Professor said before, stated relating to the violation of the cultural and archaeological heritage of the country. For example, the case of the special tribunals for Cambodia that recognized the destruction of the pagoda of the population was a crime of war, because it was intended to destroy the identity of the population, the same as with the Muslims in the ex-Yugoslavia, in the former Yugoslavia, as stated by the former tribunal, the tribunal for the former Yugoslavia, or as it happened in Darfur, because some actions towards churches or mosques were considered acts war crimes, because they were committed in order to depress the population, to stress and depress the population, because these cultural properties was not only properties but symbols of identity and cultural identity. So I think that this case of Bekina could be very interesting to you, because even if on a very national basis, it had got some stimulating point to deepen in order to understand the complex nature of the crime against crime for the protection of cultural heritage. Thank you.
Thank you, Dr. La Chioma, for your detailed illustration of a so multifaceted case, such as the Bekina case is, which I take to be a paradigmatic illustration of how difficult can be for the state to prosecute such kind of offenses because of their different types of difficulties that are involved in in the perpetration of such offenses. For instance, because of it's involving many different kinds of subjects and with different roles. Many different kinds of subjects with different entitlements to the goods involved in the perpetration of the crimes, because of it normally having a transnational dimension, which of course complicates the prosecutors' work, and so on and so far. So thank you for your lecture. And well, now I would like to know if there are any kind of interventions by our participants, or any kind of questions that our participants want to raise to our guest speakers.
Alessandro, se posso.
Sì, yes, Riccardo Modei.
Yeah. First of all, I would like to thank you to all the speakers because their lecture sparked in my mind a lot of willing, useful considerations. I will try to focus just on one consideration that is mainly addressed to Professor Malacorda, but I would be glad if I would be glad to know also the point of view of Professor Zirogiannis and of Dr. Lachioma. Professor Malacorda, in its speech at the beginning of his speech, complain about or reported of the lack of criminal law on the trafficking of cultural property. My question is maybe a bit challenging, so please be indulgent in your reply. To what extent criminal law can be useful in the counteraction of cultural property? I will try to make my point clear. Trafficking in cultural properties is a very complex phenomenon, criminal phenomenon, that could be maybe mainly divided in two big areas. The first part is the part of the looting, of the theft of the cultural objects, and maybe this part is dominated by the criminal network, the criminal association, the classical criminal network that we can bear in mind. The second part of this criminal phenomenon is very peculiar, because if we compare this trafficking with the other trafficking, we are not able to separate, to distinguish a black market from a white market. So the selling of cultural properties is defined by a lot of criminological papers as a gray market, in which the dealers, the same auction houses, sell very often licit objects and illicit objects, and they are not pushed to investigate about the provenance of the object. A really interesting paper published in a book edited also by Professor Malacorda, analyzed through a lot of interviews, analyzed the England market of cultural properties, and it underlined how if you are a dealer, if you are an auction house, and you start to make some question about the provenance of the cultural object, you are put out of the market. You are ostracized, because you are not pushed to make these questions. You just trust your first intermediaries, such for example, the case that Dr. Lachioma told us. So maybe the right question is not how we can prove in a trial that the dealers knew or should have known about the illegal or illicit provenance of the object, but maybe the question should be, how can we force the dealers and the auction houses to better investigate the provenance of the cultural properties? Maybe this is not the field of the criminal law. Maybe this is the field of administrative law, or a different regulation from the point of the selling and circulation of the cultural objects. So I think that criminal law can be very useful in the first part of the phases of the trafficking of cultural properties, but I'm not sure how it can be useful in the last part. I hope that I've been clear in my question. Thank you.
Professore, scusi, forse ha il microfono.
Yeah. Yes, thank you very much for highlighting this issue. Well, I will take the opportunity to give you some elements. I don't think I will be able to answer to you. You, Ricardo, seems to be quite an expert in this area and have been thinking about that for a while. I will actually say a couple of points that I think are extremely relevant. First of all, when I was highlighting the lack of criminal responses at the international level, I was not actually dealing with the Italian criminal law. As a source country, Italy has a very strong tradition of criminal law enforcement, sometimes ineffective for a certain number of reasons. Some of the examples which have been mentioned actually show how difficult it is to recover, even if you confiscate an asset, because it's somewhere where you don't have any judicial cooperation able to enforce the decision taken into Italy. So let's say that my observation was actually related more to the international legal framework. And Alessandro was mentioning it before, when you sit in this global arena in the UNODC, it's so actually, well, exciting on the one side and deceiving on the other side to see how countries take a different position in considering their own interests. So all I presented about the UN guidelines was actually a very, the result of a very tough confrontation at the UN level. So this is the first point. Criminal law exists, and let me say something else that unfortunately will not be exactly on the line of what I often hear in this area. We should be careful in making recourse to some criminal law tools. Confiscation, when when the offense is time limit barred, is of course it's a very delicate question that we all know from also the European Court of Human Rights, and this is something that has been challenged in some of the criminal proceedings I was actually studying on. So please be aware, not you, but in general terms, let's all be aware that using criminal law in this area, also because we want to recover these goods, should be done in the respect of a certain number of basic principles. And I had the feeling that in some of the decisions I went through, these principles were a little bit, used in order to achieve the results. So that was my first remark. It's not an answer to you. Coming to your question, well, I do think that you're highlighting a question which is how do we prevent and how do we involve private actors within this public-private partnership able to prevent the crime, because as you correctly stated, there is a certain porosity between legal and illegal market. Listening to you, it came to my mind what happened with the banks in the past, because also there you have a very mixed sources. Of course, maybe the percentage is not the same, but the source of the money the banks are dealing with is not always white, it's sometimes black. And we made a big effort, as everybody knows here, in order of tackling money laundering. And if you look at the policies of some of these private institutions and auction houses, they do have very strong AML, so anti-money laundering policies. I want to tell you that right now I submitted a proposal for a UNESCO chair, which is called Business Integrity and Crime Prevention in Art and Antiquities Market. So, I mean, finger crossed, we hope you will pass through the different steps and I will be able to give you more answers. But I think that just to conclude on this point, my feeling is that if we take into consideration the market and we do apply what is called corporate criminal liability, you are perfectly aware of, we could have a chance to increase due diligence processes and to increase preventive measures and compliance issues, which I think is actually crucial in this area. So, okay, just to conclude, punishment seems to me essential. It should be made in a balanced way. Of course, this is not a criticism to what I heard, not at all. I was extremely interested in, but the final decision in the final case was actually, for me, quite amazing on a certain number of issues. And coming to the last point, I think that you pointed out a very good direction that I'm also interested in. So thank you for saying that.
Okay, maybe the other guest speakers want to add something. In this case, I would ask to Professor Ciro Giannis to add something first, since he has to go to look after his children. So maybe you can say something first, if you have something to add, of course.
Thank you. Yes, several things actually. First of all, in response to the last question by Mr. Amodei, I would like to say that for the archaeologists, at least, is that we spent a lot of time working on these cases, and we still do. It is very disappointing to see that although in most of the cases the objects are coming back, initial offenders, they are being acquitted one way or another by the main accusations that they are being charged initially. And second, in the cases that they have been convicted, the same people, they find one way or another to get acquitted subsequently. And third, they are not being charged with new similar charges based on new cases that they derive from the original data that we have from the raids. So I'm not a lawyer, and they are, of course, in this panel much more expert people to refer to that. Dottoressa Lasioma and of course Professor Manacorda, but for me as an archaeologist, it's very disappointing to see that actually there are no charges that lead to prosecutions. Because I saw that by chance, at least the 2/3 of this session have been dedicated to Becchina. I would say that Becchina was acquitted in Italy, all in all, but in Greece has been convicted for 2 separate cases of antiquities. And in one case, his Greek lawyer went to the High Court a few months ago, and finally was acquitted because of the statute of limitations has expired for the crimes that he has been originally convicted in lower levels of the degrees of the justice in Greece. I would assume that since they found that this is a successful way of finally being acquitted by the High Court in Greece, they may follow the same way for the second case that has been convicted. And as it is now, this conviction still stands. So officially, Becchina is convicted at least one time still in Greece. I don't know how useful it is for the Italian state representatives, law representatives to know in order to build up on it, since I could understand that in some parts, at least, the Becchina case is ongoing in Italy or is intended to be ongoing in relation to possibly other crimes. I couldn't agree more now with Professor Manacorda on his point about the 1970 UNESCO Convention. It was proved actively that from the very beginning of the convention, immediately it was ignored by museums, private collectors, auction houses, dealers, and so on. The illicit antiquities trafficking continued without any problems, even after the convention. It is a very first step in theory. In practice, it didn't offer anything. It's just a reference point. So I could absolutely agree. He knows better from criminal point of view. It didn't offer really anything practically. other conventions, they have been proved a bit more useful in an active way of speaking, like the unit droit in 1995 on the perspective of the private collectors and how they should act proactively in case of exercising due diligence before they buy an object. Probably this is a way, one way at least, to push in order to actively make all the participants of this market to do something actively on the due diligence, on the provenance research area. These are the things I wanted to add. And thank you so much for the invitation, for hosting me. And I could stay a few more minutes if there are any particular questions for me to reply. Otherwise, I would leave you. But I'm available still. So please let me know.
Oh, okay. I would just like to know if Dr. Lachioma wants to add something. Otherwise, we could have some more questions.
Actually, I just confirm what I said before, that according to the criminal answer is efficient because of how it works in Italy with very long term to have a preliminary date for the preliminary hearing with very short time there's no criminal action. So sometimes I think that resort to other instruments, for example, imposing due diligence obligation on the intermediator, or as we did with the anti-money laundering legislation, or on the other side, resort to instruments that were originally built for other kind of crime, like prevention measures for mafia cases, can be more useful than resorting to criminal sanctions, because criminal sanctions sometimes are, sadly to say, regrettably ineffective. And we know it in the case of the accusation of mafia association for Bekina. It was the prosecutor that had to dismiss the case. So I think it's very honest on his side, but you can consider how frustrating to run an investigation and then to end up with saying that you cannot exercise the criminal action because everything you did was not sufficient to reach the ground for even for a trial, and not say to a verdict. So I think that sometimes it's interesting to take a look at a different perspective rather than criminal action.
Okay, thank you. Salvatore Orlando wanted to raise a question.
Yes.
Okay.
Can you hear me?
Yeah.
Can you see me? No.
No.
Why? My camera is not working.
Okay, it's not a problem.
It's not a problem. Okay. Okay. Thank you, everybody, for your speeches, and I would like to thank the speakers for the very fascinating speeches. But I would like to ask.
Salvatore, non ti sentiamo più. Salvatore?
Professor Mark that I saw on the slides of Professor Manacorda.
Forse abbiamo visto una parte.
Salvatore, potresti ripetere perché non si è sentita una parte.
Ok, I was just saying hi and thanking everybody for the speeches, and I would like to ask a very short question to Professor Manacorda, right?
Okay, okay.
I would like to start from his presentation. Actually, I would like to start from a question mark that Professor Manacorda put on his presentation on a slide. I saw when he was talking about the criminological overview. I saw a question mark next to mafia involvement. So first of all, I would like to ask why did you put a question mark? Are there no evidence that mafia is involved in such crime in trafficking in cultural goods, or it is, something that is not actually very well known? Or, I would like to ask if you can give us more details about this question mark. And in this sense, I would try to widen my question. And you were talking about this conflict in terms of approach between UNESCO and UNODC in Vienna, and about this different approach. I would say a softer approach of the UNESCO convention, which asked for administrative, pecuniary, or criminal sanctions. And on the other side, UNODC, which is trying to prosecute and punish in a more severe manner trafficking in cultural goods. So in this sense, my question is, we have a Palermo Convention. Palermo Convention goes after organized crime, transnational organized crime. As I understood, transnationality is a common that's a peculiarity of trafficking in cultural goods. So why don't we think to add a protocol to the Palermo Convention? My opinion, listening to your presentation, is that there can be three different answers to it. First, as you were responding to Mr. Omodei, is that we can't think about a very severe punishment in this to fight this phenomenon, or maybe because mafia is not actually involved, or this kind of organized and structure of criminality is not involved, or maybe because, as you were saying, there are better instruments to go after this phenomenon, as the anti-money laundering instruments. So what do you think about this perspective of adding a protocol to the Palermo Convention, and if these answers are the right answers?
Thank you so much, Salvatore. I think you raised a very important point. And I say that because I experienced it in international global arena, the efforts which have been made in order to analyze the question under this lens. And I also saw where did it bring us. So let me say that my question mark is a real question mark. I would actually say that there are clear examples of mafia involvement, and especially in Sicily. The most famous one, if I remember well, is the theft of a Caravaggio, the Nativity in San Lorenzo in Palermo, that is considered as being one of the most important, let's say, symbolic and economic theft. Even if there is no evidence or clear evidence in relation to the connection of these thefts with some mafia organizations. But that said, let's say there are, and this is clear and nobody is doubting about that, since this is a business, since it's a market, and it also happens in some regions of Italy where mafia organizations are extremely strong. I'm thinking about Sicily, but I would actually say the same about the region of Naples, of course. Well, I do think that from the criminological point of view, this involvement is clear. My question was much more related to the fact whether or not we should adopt let's say, a mafia-style criminal policy approach at international level, which was the second part of your question. So that's why you correctly pointed out this element. In my view, there was a sort of improper approach at the UNODC. I have to say that even if I was the consultant, I found myself a little bit constrained in order to analyze all the avenues that some of the representatives, either within the secretary or in the committees of the 100 states sitting there, because they wanted to have, for these kind of offenses, the same kind of legal tools that you would use in other mafia cases. And I'm sorry if I would be short and brief. My answer is no. My answer is this is not correct. This is not correct, because that brings to an enforcement where a certain what we call emergency strategy or derogation for a certain number of principles will appear as being the rule. For instance, not confiscation-based seizure, which is something I don't really like. Sorry for saying that. I cannot give you the arguments right now, but we can discuss in a separate moment. So, putting that under the umbrella of the Palermo Convention was, in a certain way, an obliged result of the competence of UNODC. UNODC could not say a word apart from the Palermo Convention, but was in a certain way also unsuccessfully. And just to give you a very last element, some of the representatives were pushing towards a third protocol, but please, when you be allowed, travel to UNODC and see how complicated it is to negotiate a not binding instrument. You will then feel yourself how impossible it is to get a new protocol without a clear consensus on that. And there was no consensus on that. United States were against, Japan were against they were against the guidelines. Okay, so just to let you know how difficult it is sometimes. I was not a negotiator, but I was the expert heading the group, and I can tell you how hard, let's say sometimes impossible, was to achieve a consensus on that. So thank you very much for your very, very interesting question.
Thank you, Stefano, for your reply. So if there are no other questions, and I ask you if there are other questions. If there aren't, I would just merely free our guest speakers and thank them for their contribution to this very interesting and insightful seminar, final seminar of our JM seminars in 2020. But before concluding, I have to give the word to Professor Militello, who has to say something, I think, as regards one next meeting related to our activities.
Yes, thank you very much to all. It was very, very interesting also the second seminar on these topics. With this seminar, all the seminars of the programs are finished, but we have next Friday a workshop on this topic for to program the next steps of our research. So all the speakers of today and the students and the participants of this important seminar are kindly invited to take part, if you want, to this next workshop that have more the goal to go forward on these problems that in these last questions of Salvatore was also in the problem. I think that it's a matter that have such problem of consents that Stefano said before, but for this ground could be interesting to know how the harmonization of these different positions are possible in the next future. So thank you very much at all, and bye to all.
Vincenzo, only to say that the next meeting is not next Friday, but next Saturday.
Okay. Yes.
Sure. At
sure.
10 o'clock. Just say
sure.
that.
Thank you. It's at Saturday at 9:30.
Yes.
9:30. Yes. Okay. Thank you very much, and bye to all.
Thank you very much.
Stefano, grazie Ciros, grazie Federica, grazie Alessandro, grazie Marta.
Thank you to you, everybody. Grazie professore.
Arrivederci, grazie.
Arrivederci.
Ciao Vincenzo, ciao Alessandro, arrivederci dottoressa, buone cose.
Buonasera, arrivederci.
Arrivederci, thank you again.